Esther. Thank you very much, colleagues, for allowing to share practice of Latvia. In general, my country is a country of successful social dialogue we are proud of, and we actually can say that our legislative acts are very strong. Nevertheless, I will now, in the next 5 minutes, name you 4 items where we see that actually realization of trade union rights is not taking place. And I first wanted also to strengthen what was said about the previous speaker about the check of trade union fees by saying that this is GDPR violations and commercial secrets, but I will name other examples. And example number 1 is coming from labor law, actually. Our labor law says that if in one enterprise there are several trade unions, and also authorized workers' representatives, so they are not trade union, they are authorized workers' representatives, they need to express a united view. In practice, this often results in total inability to realize negotiations as such, because it's very easy for an employer to make yellow authorized representatives appointed or just establish a yellow trade union. And since they all have to express a united view, the negotiations are stopped. And the employer, in a way, is not guilty in that because the trade unions could not agree among themselves. This is our very big pain that we are trying now to find solutions. And so far, on national level, it was difficult. Case number 2, or example number 2, is actually that discrimination against trade union leaders, even if discrimination is prohibited in constitution and in labor laws, then in practice, trade union leaders do not enjoy this kind of protection, because actually courts view discrimination cases against the trade union leaders as individual labor disputes. There is total lack of understanding of how, what is the freedom of associations, what is the trade union role, and when you need to realize actually to put into practice this kind of protection, it is not working. Just a very short example. For instance, trade union leader is sending a letter to the ministry, and the court is saying, since not all trade union members have signed particular these letters, the trade union leader was not authorized to send such kind of letter, which just shows total lack of understanding for trade union work. And case number 3, and this is collective bargaining in public sector and the abilities and rights of trade unions actually to bargain collectively in public sector. Because on paper it's allowed, but actually the law contains a very short and closed list of issues that trade union can negotiate about, which in practice actually does not give any possibilities to bargain. And we have reported these cases. And the last item is actually about the instrument, which is the most important to trade unions. This is the right to strike. Without the right to strike, trade union actually cannot make a proper balance with employers. And in Latvia, we also have a problem that actually strikes take time to be organized, and employers can submit a claim to find the strike application illegal. And moreover, the courts very often in evaluating this kind of claims, they start to evaluate whether trade union demands were reasonable and economically grounded, which is totally against ILO conventions. This is just the recent case of the strike of bus drivers who wanted a general agreement in bus driving sector. So these are the 4 cases where we are struggling, and which shows that when you want in practice to put trade union rights into reality, this is often not possible. We also actually find out that the Workers' Representative Institute, which is authorized representatives, is in practice reducing the role of trade unions and also creates unequal competition. And it is not easy to resolve this issue on national level as well. Thank you, Esther. These were the items I wanted to share with you, colleagues. Esther, microphone.
Thanks, Nataļja.